term land disturbance is just a smokescreen for what actually is prohibited use.
The applicant proposes to use property for temporary storage of vehicles and off-duty tow trucks, as well as to add an ADA ramp to the site.
Thank you. Good evening to the board. Appreciate the opportunity. Joseph Antonellis, I'm the attorney for the applicant. The permitting history of this particular parcel of property starts with an application for a building permit submitted by the owner, which was rejected, denied by the building inspector. And I took an appeal of that decision to the Zoning Board of Appeals. The nature of the rejection was that the use was not allowed. The applicant submitted an application that mentioned storing cars on the property, mentioned storing cars on the property, but I'll get into the specifics there. I took the appeal on the basis that it was a towing business and not necessarily a car storage facility, and argued that it fit within the definition of a service industry in the City of Framingham zoning bylaw. The Zoning Board of Appeals held multiple hearings and overturned the decision of the building inspector and issued a decision that contained significant conditions, which will be obviously, which I believe are automatically mandated to be part of the site plan approval. Thereafter, the neighbors, or a specific number of neighbors to the property, abutters, filed an appeal in the Land Court of the Commonwealth of Massachusetts. During one of the pretrial conferences, I filed a request to remand this matter to the Planning Board on the basis that eventually for the applicant to run his towing business there, he would have to come to site plan review. And there is a theory called judicial economy, which basically wants any action that could be repeated to come all at once. The judge agreed theoretically with that and remanded the case to the submission to the Planning Board for site plan review. The reason we're here tonight is to have you review this project as though there were no appeal pending. Make a decision any way that the board feels appropriate based on the evidence that'll be submitted by the applicant, and then we'll let the court determine whether or not the facility is ever used.
So, this is Brian Nelson from Metro West Engineering. And I'll go briefly through the site plan. The site plan is pretty straightforward, just about 1.16 acres. We are located in a general manufacturing zone, and there are no wetlands located within 125 feet of the site. So just a few, kind of bullet points to get you oriented to the site. The existing building is located in pretty close proximity to the sideline of Leland Street, and that's shown in brown, basically with its narrow end facing Leland Street, running roughly parallel to the rail bed. There's a smaller outbuilding, a shed, which is shown in brown towards the back of the property up at the northwest corner as well.
Just stating that if there was any activities that were involving the penetration disturbance of the soil on the property, it should be done in accordance with a soil management plan and a health safety plan, as required by the activity use limitation associated with the property. And there's a screenshot of permitted activities and uses on the site for the property done in 1999. So prohibited activities include residential uses, private drinking well water, growing fruits or vegetables, use of the property as a playground, and demolition of dike performed and supervised in accordance with the soil management plan. So that was kind of essentially the Board of Health's concern in providing the information of the activity use limitations on the site as well.
It's our understanding, based on the location of the AUL and the limitations, that this project will have no impact on that. We do not intend to disturb any of the earth in that area, and any of the activities that are prohibited under the AUL are not intended for this property. Another comment: the decision that was issued by the Zoning Board of Appeals, if it is subsequently upheld, required that any cars that are damaged, that are towed to the property after an accident, are placed in the corner where the existing cement walls are, so that they're screened from view and encapsulated in a specific area. Then the rest of the site could be used for storing cars, storing could be used for storing cars, for towing cars to the site that have been towed off the street for snow purposes or because of a drunk driving or something that's police related. We can certainly show an area with perhaps some kind of preliminary striping or something to give you a limitation of the area that would be used. And at the same time, I think Brian can put in enough to, with a turning program to show that a fire apparatus can get around where the cars would be stored, where the cars would be stored to any other area.
I look at the paved areas that are there and understanding that vehicles, as they're towed in, whatever the reason they are, have a lot of different fluids that could be spilling from them, and how are we going to contain that in the site itself?
There's an area there that is basically concrete walls that I think are about 4 or 5 feet high, and the intention was, there used to be trucks stored in there and tanks. The intention was that any vehicle that was damaged in an accident would be brought to there and not left out in the other part of the yard where Brian will have to show you at the next meeting where they'll be stored, where they'll be stored.
And I think the use years ago, they would put the chemical trucks in there, and it had a concrete floor. So it's basically like a big 60-foot by 40-foot high-walled pit with a concrete floor.
It doesn't have concrete, it says gravel.
Is it gravel on the floor of that? Okay.
How many trips a day have you projected?
Again, I think it is a number that is dependent on what happens on a daily basis relative to the number of calls that the applicant would get in his business.
Well, that's a very vague answer, and I do want concrete answers about that. Now, my understanding is that a good portion of this area is in the vicinity of residential.
The site is located in the manufacturing
I
district,
understand
as you
that.
know.
That wasn't my question.
And there are a significant number of residences across the street and to this facility. When the zoning board of decision went out, application was filed, the list of abutters showed a significant amount of residences in the area.
Yes, thank you for your candor on that.
I think we'd like to hear from the public on this, and it appears Judy Grove would like to speak.
A lot of people know me. I was town meeting member. I was District 8 City Councilor, chair of the Environmental Subcommittee, an environmental activist, and now I'm on the Community Preservation Committee. I've been listening to what the applicant has been saying, and I can answer many of your questions for you because we've asked these questions before. One of the residents here today is Shirley Adams. She lives at 81 Leland Street. The ZBA had 4 hearings before they finally decided what they were going to do to come here, because this is a prohibited use. According to the zoning bylaws, prohibited uses are uses that are harmful to the public. And in this case, it is expressly prohibited that you cannot have a vehicle storage yard. The interesting thing I learned, it has now been 2.5 years that we've been in land court. We've had joint meetings, we've had hearings, and every time we have a hearing, the applicant says they're not ready, they're not ready. They said they had to go to the planning board. But if you watch the ZBA meetings, they said they couldn't go to the planning board because you can't have a site plan review, you can't have conditions on a prohibited use. So the next thing they thought was we've got to be something other than a vehicle storage yard. So they said they were a service business. Now the trouble is that they were told by the planning board administrator, Amanda Loomis, that they were a tow yard, a vehicle storage yard. She was very clear in her letter, and I've given you a copy of that letter. She also said, you're not a service business. In no way do you fit a definition of a service business. So what we thought they were going to do was to continue to claim they were service and come to you saying they were service business. But if you look at their application, it clearly says they are a vehicle storage yard. That is what they are. For the number of cars,
I'm sorry, what application are you referring to?
the application to you for site plan review says vehicle storage yard. It does not say service business. Now, Shirley Adams pinned them down at a meeting. How many cars? 100 cars, they said. At another meeting, the applicant was asked how many tow trucks. He has 40 tow trucks. His business, Exceptional Auto, is right around the corner. So in order to get to his tow yard, he will go by the residence we're talking about. One day he said, if there's a snowstorm, I could tow 40 cars in one day. Then the issue was, let's not call it a tow yard, let's call it a tow business. The cars will only be there for a few days. One member said, that's not right. They'll be there more than a few days. For instance, it was Mr. Cosgrove. I went on a honeymoon, and they towed my car, and I found out that morning I was going to be gone for 2 weeks. If I hadn't found out, I can't even tell you what it would cost me. So he said, it won't be a few days. So they kept playing with the number. How many days will it be? Then they said it would be 15 days. And at one point, one of the members of the board said, you don't like 15 days? Okay, I'll give you 21 days. So this is what has been going on for the last 2.5 years. We went to the hearings. We weren't allowed to speak at the final hearing because they had closed it. But because they couldn't make a decision, they closed a hearing, and then they reopened it so they could have more time to talk. At that last hearing, the building inspector said to them, you are not here asking for permission. You are here asking for forgiveness for what you have done. So we had to go back to the beginning. The owner of this property asked people about that property. He knew it was a prohibited use. So he went ahead with no permits, and he remodeled that building. They did plumbing and electrical work. They changed the doors. The building inspector came down and saw it because neighbors were complaining, and he issued a cease and desist order, which is one of the documents I gave to you. He said you are not to do anything. You don't have permits. So then they did apply for a permit, and he denied them. You're clearly a prohibited use. There's no question about it. So then they went to the ZBA. Once they went to the ZBA, I found out about it, and I have been supporting the environmental justice neighborhood. So I spoke with the neighbors, and we have many of these neighbors in our suit, and I filed the suit in court. 2.5 years have gone by because they don't know how to deal with the issue that it's a prohibited use. And I want to say for the public, our zoning bylaws were written to protect us, and they should know that what they mean by prohibited uses. All uses that pose a present or potential hazard to human health, safety, welfare, or the environment through emission of smoke, particulate matter, noise or vibration, or through fire or explosive hazard or glare are expressly prohibited in all zoning districts. The following are expressly prohibited: anything that produces noise, which they've already said, and then a vehicle storage yard or an automobile storage as primary use. One of the arguments they tried to make was this is not the primary use.
Okay, I got to stop this for a second. I've read your entire, all the documentation you provided. We are not the Zoning Board of Appeals, and we are not the court that is ruling on, but we have to make a decision based on the scope of what we're doing here. We can't make a judgment that, we're not judges. So the judge is going to make a judgment, and we're not the zoning board.
You are the people who write the zoning bylaws.
Yeah, I understand that, but do you want us to do what we're supposed to do?
Address the zoning bylaws specifically.
Well, if you get to it, but we don't want to hear the whole case for 3 hours.
Yeah,
Two.
but we're faced right now with a zoning board of appeals decision that says this is a permitted use because, and I understand your legal arguments that this is not a permitted use. But given that we have to use this decision as it stands, unfortunately, there are certain things that we can look at. For example, we have to make sure that it retains the community character, blends and harmonizes with the architectural style, screens objectionable features, no noxious, there's a whole list of things that we need to look at. And so we're going to drill down on those. And, you know, some of them would have to minimize vehicular traffic and safety impacts. So we're going to be looking at that. But we still have a limited discretion and limited authority.
How do you get a car off of a tow truck? I called a tow yard, and he explained it to me, and there is a video on YouTube. If you don't have the keys to a car, the way you get it off is you shake it off the truck. The truck moves back and forward, and there's a huge thunderous sound, and then they dump the car. So if you can imagine the middle of the night that residences are trying to sleep and they're going to be hearing these sounds. The other thing is there are 8 tow yards in Framingham, all of them within a mile of the site. So in terms of land use, the planning board's big mandate is proper land use. To put another tow yard into Framingham, it just means that we're just a place where you can have bad uses. If this is allowed, how will it keep the ZBA from ever just saying they can override every prohibited use you ever list? They do it and you can't do anything about it. I think it really sets a precedent. And I think you understand what I'm saying, but there is a quote from a law journal that I think is very important to this case. And you are the zoning people who do the zoning. It was 2015 when they put the prohibited use because we had been in front of them about a very bad situation at 350 Irving Street, a gas plant with 15 fires in the piles. So we talked about Mary Dennison, we talked about General Chemical, they're all surrounding this land. So they changed the bylaws then, and they made it a prohibited use to have vehicle storage because they considered vehicle storage, auto use, as one of the worst uses our city could have, and we have about 125 of them in South Framingham. So this is from the Law Journal.
25 what?
About 125 auto uses in South
Auto
Framingham.
uses or
Vehicle
storage?
storage yards?
Yeah, well, they're little garages, they're repair shops, they're paint shops, they're every kind of use. See, there are 8 tow yards, and you might not realize it because lots of businesses tow cars and store them on their land. And that's another thing, the drainage in garages. We don't know if anybody's really monitors that. But I think this is an important statement. Zoning laws determine what types of land use and densities can occur on each property lot in a municipality, and they also govern the range of potential environmental and health impacts resulting from land use. Zoning has enormous implications in general for shaping our environment, and because changes to zoning are made through a political process, it has possibilities for abuse. It is a very political process. The uneven spatial distribution of noxious uses and the potential adverse effects are a major focus of environmental justice research. Finally, one of the members of the board is a neighbor of this applicant, and he was often called by his first names by members of the board. And Mr. Tassino pointed that out at the final hearing, that he felt that there was an issue of that in this case. And I certainly think that's something that should have been investigated.
Again, we're talking about planning board. That's a zoning board legal case that we have no impact on, and we shouldn't be hearing.
Well, also, Mr. Norton, you were an alternate.
Again, I know I was on the meeting, I know I was an alternate, but whether Susan Craighead has a conflict with the applicant really has
did
no
not
bearing on
mention
this.
her name, but you
I
did,
did, because I was there. It doesn't affect whether our decision.
Do you think it's right that you're hearing this case when you sat on that case, though?
If you don't think it's correct, talk to town council. Yes, I was told in a letter that I could sit on board. I'm not going to argue that with you, and I'm not going to tell you again. Keep it to the planning board. Don't tell me what happened 3 years ago at the zoning board, because it has no bearing on this.
It has a tremendous bearing on you if they can override your prohibited uses. That's my main concern here. And this environmental justice neighborhood has made some strides. They tore down the houses at General Chemical, and now they're going to get 100 towed cars. How wrong can you be?
Oh,
Yes, I'm Shirley Adams, and I'm in a butter for the property. And I just want to say that this is an example of complete decay for regulations that are written. That this had to go on for 2.5 years when the regulation was put in, and the building inspector told him that and the repairs and the remodeling was done. So all of this over 2.5 years, it's just complete decay.
Yes, Rhonda Andrews. I'm in District 9. I live around the corner from the proposed auto tow business storage yard. And I'd like to say that that property, as you know, was originally, was previously used by a sister company, Clean Ventures. They were a sister company of General Chemical, and they stored their transfer trucks there. That was their business. And then when Exceptional Auto bought that property, they went ahead and started moving the ground around without any permissions, without an LSP or any, just no permits, and just started moving the ground around. My other point would be that this was you people made this a prohibitive use, and to go ahead and allow them now to go ahead and use that for these purposes, it's just, I think that there's been enough information that you've just heard tonight to color this as a very bad use for that property. Very bad use. I'm just hoping that you people do the right thing for this neighborhood.
I live at 98 Leland Street. I would say it's about 200 to 300 feet away from the area. I have a few concerns. I have 2 kids, one 16 and 6 years old. My late wife, short story, she passed away with a cancer when my son was 1 year old. So when he was generating inside the body, she already had a cancer, and I always have a concern about chemicals and things like that that can harm. And before was General Chemical, they were going to clean the floor. Now could be another harm way in the ground. Who's going to follow up and make sure they are doing what they are supposed to do, besides the traffic that's going to increase. The loud noise for the trucks coming in and out the place, most of the trucks, it's reckless drivers. That's, I've been seeing a lot. Mid of the night noise, my kids crossing the road to get the bus to go to school. What if some of the drivers on a reckless driver hit my kids or do anything like that? And basically right across that, there is a school where kids walking back and forth almost all year long. There is a really concern about this. Besides the regular traffic, it's impacting our lives. Now we're gonna bring more traffic, more harm, with the more people flying by down the road. I really concerned about this move forward.
I just wanted to piggyback on the traffic issue and the what was stated earlier about they were not sure how many cars would be in and out, but they already have a tow company that's presently running. So they should be able to give an estimated number of vehicles pretty easily. They said upwards of 40 at one point, and I know that multiple people have already mentioned the traffic issue. But if there's upwards of 40 tows a day, that's going to substantially increase it's already crazy right now as it is on this street, with buses backed up from the school at the end of the street, and when the train comes by, cars are backed up around the corner. And then in the middle of the night, the noise. this street is already a cut through for the Odessa Auto Yard. And since I've been working from home for the last year, I've noticed it even more so, just the amount of noise that goes up and down the street at all hours of day and night. It's just going to increase dramatically. And then I guess the other question I really had was, they said that there was a spot for any cars that had been in accidents leaking fluid. Well, what happens where do they put those cars? Do they just not tow them, or are they going to take up the rest of the spaces that are for cars that aren't involved in accidents? So then that runs into whatever drains from the site itself, the gases, the oils, anything that's in the accident. So I guess those were my main points, just on the environmental issue and the traffic issue.
My name is Thomas Grove. I'm a professor at Framingham University. That zoning has enormous implications in general for shaping our environment. And because changes to zoning are made through general political processes, possibilities for abuse, the uneven spatial distribution of noxious uses and their potential adverse effect are a major focus of environmental justice research. The area that we're talking about in Framingham has achieved notoriety for its clear bearing of that title of an environmental justice neighborhood. So I think this is especially important for your planning board with its adherence to standards for the community to understand what Shirley Adams was talking about, the decay that is going on here, when slowly and surely what standards were there, what was once farmland is now being degraded, and the elementary school, which is only a few steps beyond the residents, are going to be affected by this too. If that has to be, to me, included in the culture of the community, what are these children that are walking past this place? What about them? You had a report from a concerned parent. Is this not part of the culture, the standards that should be addressed? Thank you.
What's before the planning board, of course, is the minor site plan review, and looking at the site plan review requirements in the land disturbance and stormwater management special permit that the board needs to approve as well. So
if this board says yes, we vote yes on everything, and the judge says, or the judge rules no, that the zoning board didn't have the ability to grant that special permit,
Sure.
This all goes away.
I think the decision would have to be based on,
I can't speak on court matters and how court procedures roll through. That would be up to legal counsel.
I did speak with Counselor Terry. He's one of the attorneys who works in Solicitor Petrini's office, and I have the same questions as everybody else, you know, exactly what is the purview of our review. And basically what I was told is that we should treat this like any other application that is before us. We use our existing regulations to review the project. So we have site plan review, which is non-discretionary, but there is a discretionary special permit through land disturbance to go through the review, and this will all go back to the court. The court is essentially, from what I was told by the solicitor's office, is gathering their information so that they can render a decision, because this was brought forward on an appeal of an overturning of a building commissioner's decision, which is a procedural appeal. So by doing this process and sticking to our, you know, our existing regulations, you know, as the Vice Chair noted, we're not making a substantive judgment on what's appropriate here. We're not necessarily having that discussion. The Board of Appeals rendered an opinion, and now it's before the court. The court needs to see an analysis, and they are directing us to conduct that analysis through site plan review and the land disturbance.
I think we're definitely continuing. I'm not voting on this tonight. I share the same concerns about the amount of traffic. This is that's something we need to consider. And hours of operation being full-time with everything having to go through a neighborhood. One of my biggest concerns is the ability to contain whatever is coming off of a vehicle. And I also share the concern about whether it's even reasonable for anyone to enforce the whole, okay, well, that space already has 20 cars in it that are damaged, and we got another one. We have to do something with it. Well, we're gonna have to put it outside of the special containment area. And what does that mean? And that sounds to me like an enforcement issue that's very difficult to expect anyone to be able to do. And if provisions are being made to contain, then how is that regulated and followed? I don't know how that is.
Thank you to the board for your considerations and patience tonight.
Thank you.
Appreciate it.
I just want to say the term land disturbance is just a smokescreen for what actually is prohibited use. Site review should never have come here